students, I am Tulika Banerjee. Today I bring you the next learning episode in BSc Forensic Science on behalf of the content writers Dr. G.S. Sodhi and Deepika Bhandari on an important unit of paper Crime in Society, that is Criminal Justice System Part 1. In this episode, we will discuss about the essential components of criminal justice system, policing styles and principles. We would also acquaint ourselves with the concept of police power of investigation. Let us start this lecture with a brief look at what we are going to learn today. First is Introduction to Criminal Justice System, essential components of criminal justice system, policing styles and principles, police power of investigation, and the conclusion. Criminal justice system refers to the structure, functions and decision processes of agencies that deal with the criminal prevention or the crime prevention, investigation, prosecution, punishment and correction. Article 10 of Universal Declaration of Human Rights, that is UDHR, laid down the foundation of the international principles of judicial independence and provides that every person is entitled in full equality to a fair and public hearing by an independent and impartial tribunal in the determination of his rights and obligations and of any criminal charges against him. Similarly, Article 14 of the International Covenant on Civil and Political Rights, that is ICCPR, says that all persons shall be an equal before the courts and tribunals in the determination of any criminal charge against him on his rights and obligations in suit at law, and everyone shall be entitled to a fair and public hearing by competent, independent and important tribunal established by law. It must be realized that an unjust acquittal is as much a miscarriage of justice as an unjust conviction. Rule of law is the operating instrument of justice in a civilized society. The Constitution of India and the Criminal Justice Administration have a reciprocal relationship. While the Constitution sets certain ideals of securing justice to the people and maintaining unity and integrity of the nation, the Criminal Justice Administration comprises of the police, judiciary and prisons. These agencies constantly depend on the constitutional support to their principles and the procedures. The final goal of criminal law is to protect the right to personal liberty against invasion by others, to protect the weak against the strong, law-abiding against lawless, and peaceful against the violent. For the protection of rights of citizens, the state has prescribed the rules of conduct, sanctions for their violation, machinery to enforce sanctions, and procedures to protect that machinery. It is an absolute egotism, greed and chauvinism that initiates deprivation of life, liberty and property of other citizens, requiring the state to step in for protection of the citizen right. The foundation for the criminal justice system is the investigation by the police. When an offence committed is brought to the notice of the police, it is their responsibility to investigate into the matter to find out who has committed the offence, ascertain the facts and circumstances relevant to the crime, and to collect the evidence, oral or circumstantial, which is necessary to prove the case in the court of law. The success or failure of the case is dependent on the work carried out by the IO or the investigating officer. Regrettably, the police are not trusted by the criminal justice system. Rather, the police are viewed with suspicion by the courts and hence confidence is not reposed in them. Article 246 of the Constitution provides 3 lists which are enumerated in the 7th schedule of the Constitution. List 1 is the Union list, which enumerates the subjects on which the Parliament of India has exclusive power to make the laws. List 2 is the state list, which enumerates the subjects on which the legislature of a state has the power to make the laws. The third list is the concurrent list, which enumerates subjects on which both the Indian Parliament and the legislatures of the state can enact laws. But if there is any conflict or inconsistency between the laws made by the Indian Parliament and that of the legislature of any state, the law enacted by the Union Parliament will have overriding effect. Importantly, the public order and the police are enumerated in entries 1 and 2 respectively of the state list, meaning thereby that all matters relating to the organization, structure and regulation of the police force fall within the ambit of the states. However, the criminal laws and the criminal procedure are enumerated in list 3. Both the Indian Parliament and the state legislature have the powers to make substantive and procedural laws in criminal matters. Keeping in view the importance of the criminal justice administration, the framers incorporated in the Constitution itself many provisions relating to the administration of criminal justice. They intended to establish a just society in India by ensuring fair and speedy criminal justice to the people. This required a qualitative improvement in the performance of the criminal justice administration. The criminal justice system has 4 important components in India, namely the investigative agency or the police, the judiciary, the prosecution wing and the prison wing. Correctional services. First is the investigation agency. The police forces are raised by the state under the Indian Police Act of 1861. The basic duty of the police forces is to register cases, investigate them as per the procedure as laid down in the Code of Criminal Procedure or CRPC and to send them up for trial. In addition to the state police forces, the Government of India has constituted a central investigating agency called as the Central Bureau of Investigation or CBI under the special enactment called the Delhi Special Police Establishment Act, that is DSPE of 1946. It has concurrent jurisdiction in the matters of investigation in the Union territories. It can take up the investigation of cases falling within the jurisdiction of the states only with prior consent of the state governments concerned. There are certain other specialized investigating agencies constituted by the central government in various departments, namely the Customs Department, the Income Tax Department, the Enforcement Directorate, etc. They investigate cases falling within their jurisdictions and prosecute them in the courts of law. Thus, India has both the state police investigating agencies and the central investigating agencies, as I have already told you. CBI, however, is the primary investigating agency of the central government. Next, we will be discussing here about courts. The cases instituted by the state police and the central investigating agency are adjudicated by the courts only. We have a 4-tier structure of the courts in India. At the bottom level is the Court of Judicial Magistrates. It is competent to try offence punishable with imprisonment of 3 years or less. Above, it is the Court of Chief Judicial Magistrate, which tries offences punishable with less than 7 years. At the district level, there is the Court of District and Sessions Judge, which tries offences punishable with imprisonment of more than 7 years. In fact, the code specifically enumerates offences which are exclusively triable by the Court of Sessions. The highest court in a state is the High Court. It is an appellate court and hears appeals against the orders of conviction or acquittal passed by the lower courts apart from having writ jurisdiction. It is also a court of record. The law laid down by the High Court is binding on all the courts subordinate to it in a state. At the apex, there is the Supreme Court of India. It is the highest court in the country. All appeals against the orders of the High Courts in criminal, civil and other matters come to the Supreme Court. This court, however, is selective in its approach in taking up cases. The law laid down by the Supreme Court is binding on all the courts in the country. The charge sheets filed by the police are in fact inputs for the trial courts. Efficacy of the criminal justice system hinges on the prompt completion of trials and higher conviction rates. The opposite of it would be symptomatic of the systemic failure. The third is the prosecution wing. It is the duty of the state to prosecute cases in the court of law. The state governments have constituted cadres of public prosecutors to prosecute cases at various levels, in the subordinate courts and the High Court. Public prosecution is an important component of the public justice system. Prosecution offender is the duty of the executive, which is carried out through the institution of the public prosecutor. The state appoints the public prosecutor, whereby prosecution is carried out by the prosecutor in lieu of the state. Although the public prosecutor is responsible in seeing that conviction takes place from the trial results, he should not be overwhelmingly concerned with the outcome of the trial. He is an officer of the court and is required to present a truthful picture before the court. Even though he appears on behalf of the state, it is actually and equally his duty to see that the accused does not suffer in an unfair and unethical manner. The public prosecutor, though an executive officer, is an officer of the court and is duty bound to render assistance to the court. The public prosecutor represents the state and the state is committed to the administration of justice as against advancing the interest of one party at the cost of the other. He has to be truthful and impartial so that even the accused persons receive justice. The public prosecutor plays a dominant role in the withdrawal of a case from the prosecution. Next, here we will be discussing about prisons and the correctional services. This is the fourth important element in the criminal justice system. The prisons in India are under the control of the state governments and so are the correctional services. The main objective of the criminal justice administration is not merely to punish the offender, but to effect changes in his behavior in the overall interest of the society. This calls for correctional agencies to decriminalize and reform the offenders to make them fit for society and not to dehumanize them by giving harsh and inhuman treatment. The prisons, reformatories, borstal institutions and other institutions of like nature are included in the state list under the Constitution of India. The legal base for prisons is Section 4 of the Prisons Act, which requires the state governments to provide accommodation for prisoners in their territories. In prisons, which as per Section 3 means any jail or place used permanently or temporarily for the detention of prisoners. Further, under Section 417 of the Code of Criminal Procedure or CRPC 1973, a state government may direct in what place a person liable to be imprisoned or committed to custody is to be confined. The police forces in India are broadly divided into two, namely the state police. As regards the police set up in the states, the entire police establishment under a state government is deemed to be one police force. State police are further classified of two categories. First is state establishment system. The superintendence of the police throughout a state is vested in and is exercised by the state government, and except as authorized under the provisions of the Police Act 1861. No person, officer or court can be empowered by the state government to supersede or control any police functionary, since for maintaining police order in the Union Territories, the Union Territory Police, though under the control of the central government, functions on the pattern of the state police as prescribed by the Police Act of 1861, and therefore, wherever state police is referred, it also includes Union Territory Police unless otherwise stated. In state establishments, officer of the rank of DGP is posted as the head of the state police. However, in pursuance of the provisions of the Police Act, the head of the state police is still designated as Director General of Police or DGP and Inspector General of Police or IGP. The state is divided into convenient territorial divisions called police ranges. Generally, an officer of the rank of Deputy Inspector General of Police or DIGP is posted as head of the police range, but in some states, the practice of posting Inspector General of Police or IGP as an in charge of police range has come in vogue. A police range consists of a number of districts. The administration of the district police under the general control and the direction of the district magistrate is vested in an officer of rank of Superintendent of Police or SP. The whole area of the district is divided into police stations, which are considered the basic units of the state police. An inspector or sub-inspector is posted as officer in charge of the police stations, who in some states is also known as station house officer or SHO. Although the jurisdiction of a police station is further subdivided into police outpost, police chowkees or police beats. A group of police station forms a police subdivision, which supervised by a Deputy Superintendent of Police or DYSP or Assistant Superintendent of Police or ASP. In most of the states, the in charge of the subdivision is designated as Subdivisional Police Officer or SDPO, while in some states he is known as Circle Officer or CO. The next type of system is the commissionerate system. Some states have set up police commissionerates in some cities. Under this system, a certain area of one or more districts is put under the control of a commissionerate of police or CP instead of Superintendent of Police, that is SP. Initially, commissionerates of police were appointed for metropolitan cities only, but the recent trend is to create police commissionerates even for smaller cities. A commissioner of police may be of the rank of DIGP or IGP or even additional DGP or DGP, according to the size and sensitivity of the area. Officers of the rank of SP can also be appointed as Commissioner of Police in some states. In police commissionerates, the district magistrate does not have the powers of general control and direction of the police, as these powers are vested in the Commissioner of Police. The Commissioner of Police is also empowered under various laws to issue arms and ammunition licenses, to license and control places of public entertainment and public amusement, to issue prohibitory orders and to detain persons under preventive laws. These powers are exercised by the district magistrates in the areas which are not under the control of the Commissioner of Police. A police commissionerate is divided into various territorial units such as the regions, zones, divisions, etc. Officers of the rank of DYSP, SP, DIGP and IGP are posted as Assistant Commissioner of Police, Deputy Commissioner of Police, Additional Commissioner of Police and Joint Commissioner of Police respectively, to assist the Commissioner of Police All these officers enjoy magisterial powers under the provisions of the CRPC and other state or central acts to effectively discharge their duties of crime prevention and maintenance of law and order. The next type is the central police organizations. The Union government has created its own central police organizations for discharging certain specific duties such as investigation, vigilance, collection of intelligence and to assist the police forces of the states in certain situations such as elections, natural calamities, VIP security, etc. Since the central police organizations play a definite role by assisting the state police forces and supplementing police functions, they play an important role under the criminal justice system. Following a few of the central police organizations, starting with the very first we have Central Bureau of Investigation or CBI, Intelligence Bureau or IB, Border Security Force or BSF, next is Central Reserve Police Force or CRPF, Indo-Tibetan Border Police that is ITBP, Assam Rifles, Central Industrial Security Forces CISF, National Security Guards NSG, Special Protection Group SPG, Bureau of Police Research and Development BPRND, National Crime Records Bureau NCRB, LNJN National Institute of Criminology and Forensic Science. Now dear students, let us discuss about the police power of investigation. Police power of investigation includes the police functions like crime registration, guarding, protecting visit to the scene of crime, lifting, handling and packing of exhibits and sending them to various places like the police station, office of the superintendent and the forensic science laboratories and other places, calling witnesses and serving notices to them, arresting criminals and suspects, search and seizure proceedings during an investigation, interrogation of suspects, witnesses and criminals, collection and recording of various types of evidences that is oral, documentary and expert opinion etc., taking criminals to courts for police or judicial custody and trial, rate for various purposes. Investigations in India are conducted as per provisions of chapter 12 of the code. Cases are registered under section 154 of the code. A police officer is competent to investigate only cognizable offences. Non-cognizable offences cannot be investigated by the police without obtaining prior orders from the courts. A police officer can examine witnesses under section 161. However, these statements are not to be signed by the witnesses. Confessions of accused persons and statements of witnesses are recorded under section 164 of the code. A police officer has the power to conduct searches in emergent situations without a warrant from the court under section 165. A police officer is competent to arrest an accused suspected to be involved in a cognizable offence without an order from the court in circumstances specified in section 41 of the code. He is required to maintain a day-to-day account of the investigation conducted by him under section 172. After completion of the investigation, a police officer is required to submit a final report to the court under section 173. After completing the investigation and obtaining legal opinion from the prosecuting personnel, the police investigator either establishes a charge sheet accompanied by statements of witnesses before the competent magistrate under the appropriate section of law, or in the event of insufficient evidence, files a final report dropping further action. If the defendant is charged during the trial, it is the responsibility of the investigating officer to assist the public prosecutor in every way, including the production of witnesses. Police may arrest without a warrant and without an order from a magistrate. any person who has committed or is suspected to have committed a cognizable offence. Police may also arrest persons for the purpose of preventing the commission of such an offence without a warrant or order. Very few arrests are made on the basis of a warrant. Normally, a warrant is obtained by the police to search a place. However, when an officer believes that a material needed for investigations available in a certain place and concludes that the loss of time incurred by obtaining a warrant would be prejudicial to the investigation, he may search the place without a warrant after recording the grounds for his belief. Any police officer may seize any property which is alleged or suspected to be stolen or which is found under circumstances which create suspicion of the commission of any offence. The ultimate goal of the criminal justice system and the criminal law is to protect rights and personal liberty of individuals and the society against its invasion by others. The criminal law aspires to protect the weak against the strong, law abiding against lawless, and peace against violence. In respect to the protection of rights of the citizen, the state prescribes various rules of conduct, sanction for their violation, machinery to enforce those sanctions, and a code to protect the machinery. Often it is the selfishness, greed and ill tolerance that leads to deprivation of the various rights of an individual. For over some decades, there has been a growing demand for amending the criminal justice system. Several amendments have been made since independence in this regard. To the effect, the entire Code of Criminal Procedure or CRPC was amended in 1973, or in fact an entirely new criminal procedure code was adopted with the same. Yet the inadequacy of the system has been posing not only grave challenge to the legitimacy of the system, but also affecting the social system adversely. The courts are constituted by the state government and the court, and the cases are prosecuted by public prosecutors appointed by the state government or the central government, as the case may be. Even though the National Crime Records Bureau has been gathering data about the disposal of the cases by the courts, the statistics do not seem to be authentic. It has been aptly remarked by a wisecrack that the place of a nation on the civilizational scale is to be determined by the manner in which the criminal laws are enforced. Since all the elements of the public justice system are interdependent, even the strictest enforcement of law by the police agency will not deliver the goods unless it is supported by the judicial system by way of prompt disposals. The role of public prosecutor and his performance is also to be judged by the ability of the assist the court in this regard.